My case is West Virginia State Board of Education versus Barnette. As the late 90s laid inevitable toward World War, patriotic fervor grew in America. Part of that fervor included laws requiring school children to salute the American flag and recite the Pledge of Allegiance, but Jehovah's Witnesses refused to participate. They believed saluting the flag violated the commandment against graven images or likenesses. But in 1940s, the Supreme Court held in a Govitis case that a mandatory flag salute was constitutional, and that decision signaled open season against Jehovah's Witnesses. Their kingdom halls were burning down, often of police and freedom fighters' watches. Jehovah's Witnesses were harnessed, beaten, and run off their homes. One sheriff asked why he allowed such violence, replied, "They are traitors, the Supreme Court says so." The press was outraged, and even First Lady Eleanor Roosevelt commanded the violence. After Govitis, the West Virginia Board of Education enacted a mandatory flag salute rule. Refusal to participate unconstitutional insubordination, which could result in a student's expulsion. Expelling children were considered unfairly absent, subjecting them and their parents to penalties. Barnette and other Jehovah's Witnesses sued the Board of Education in federal court. Despite Govitis, a three-judge district court panel enjoined the board from compelling Jehovah's Witnesses children to salute the flag. In the Board of Education, they appealed directly to the United States Supreme Court. The whether in this case is, does the First Amendment require the school to exclude Jehovah's Witnesses from the compulsory flag salute? Rule of law. The case asked the courts to consider whether the First Amendment required the board to excuse Jehovah's Witnesses from the compulsory salute. But instead, the Supreme Court went further, holding that the First Amendment prohibits compelling anyone to salute the flag or recite the pledge. Justice Robert Jackson, who joined in the court after Govitis was decided, wrote the court's opinion. Jackson explained that government may censor ideas only if their expression constitutes a clear and present danger of an injury. Jackson reasoned that if government power to censor expression is so limited, the government power to compel expressions can only be justified by an even great showing of danger. Since the freedom that Barnette claimed didn't interfere with anyone else's rights, the children's refusal to salute the flag wasn't a threat of many sorts. The Govitis majority had presumed that the governments had the power to compel to salute and only considered whether Jehovah's Witnesses were entitled to the exception. But the Barnette Court determined that the First Amendment expressed and religious freedoms made applicable to the states, but the 14th Amendment prohibited the form from compelling expression of national unity. Justice Jackson summarized the court reasoning in a passage that still resonates to date. Quote, "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox on politics, nationalism, religion, or other matters of opinion, or for citizens to confess by word or act their faith therein. Unquote. With these words, the court overruled Govitis and affirmed the district court's injunction. Justice Black and Douglas joined the majority opinion, but also wrote a concurrence together. Both had voted with the Govitis majority, but now wrote to explain their change of heart. Before they'd been afraid to create a reading bar against state regulation of conduct detrimental to the public welfare. However, they failed to appreciate just how much the compelled salute restricted religious freedom. The compelled salute was akin to a test of which they considered aberrant in American society. Justice Murfield also concurred, noting that a compelled flag salute is nothing but an empty gesture, far overhead by the value of protecting freedom of thought and expressions. Jews of Felix Frankfurt dissented, referring to his Jewish heritage as a member of quote, the most violent and persecuted minority in history, unquote. He sympathized with the Jehovah's Witnesses, but he was reluctant on strike down duly enacted laws. Frankfurt considered legislation as much as court to be responsible for protecting citizens' rights. The board's rule authorized by the West Virginia legislature didn't discriminate against an unfair haircut. It applied equally to the Jehovah's Witnesses as to all other faiths. Therefore, the law didn't violate the First Amendment's religious clauses. Justice Owen Roberts and Stanley Reed also dissented, asserting that Govitis was correct decided. Conclusion. This case was decided in 1940s, but the remains of cornerstone of fierce and jurisprudence through many tumultuous periods in United States history. Justice Jackson's inspirational language has stood the test of time, acting as guiding light to a free and democratic society.